Hello, welcome once again to Leto's Law. I'm Steve Leto. Matthew sent me an email and asked me a question, which I think is a great one. And I've been asked this before, but he actually laid out all the hypotheticals on it and really got me thinking. So I thought, something, this is such a good question. I've got to answer it. And here's the question. I'm an attorney practicing law in Michigan for almost 28 years now. I don't do a lot of criminal work, but I'm familiar with it. And of course, I studied it in law school and I passed the bar on it too. But here's the deal. Suppose you're an attorney doing criminal defense work and an accused defendant, someone who's accused of a crime, comes into your office, sits down and says, I want to hire you to defend me. Okay? And you say, okay, cool. I need the work. Pay me some money and I'll defend you. And during the course of the representation, the person says, oh, by the way, just want to let you know, I did it. I'm guilty. I'm as guilty as the day is long. They accused me of a crime. They got the guy. But we're going to go to court and fight it anyway. Okay? Are you cool with that? And Matthew actually gave me a bunch of different examples of, what happens if you know they did it versus you think they did it versus they tell you they did it, that kind of thing. And of course, there are a couple different ways of looking at this, but the important thing is this. Michigan and its attorneys follow what are called the Michigan Rules of Professional Conduct. And in most states that I'm aware of, they have rules on ethics, the rules that attorneys must follow to be able to practice law. They must behave ethically. And the rules address specifically the relationships between the attorneys and the court, the attorneys and the client, and the attorneys and everyone else. Okay? And so you can get in trouble if you behave unethically in any of those three settings. And so what we're talking about here is basically the relationship between you and your client and you and the court. Because you can talk to your client all day long. Your client says, look, I did it, but I need some help. That's not going to be the problem. The problem, of course, is how you're going to go to court and present it to court. So there are two rules that come into play here, and I believe that most states have got parallel rules on this. So it's simply a matter of what the rule is in your state. And I'm not expecting you to look this up because the rules of professional conduct are very confusing. They're worse than laws because laws are written by legislators for courts to interpret and attorneys to argue over. The rules of professional conduct are simply written by courts and are only dealing with attorneys. And so they've actually added, I believe, a layer of complexity. Perhaps just to mess with us, I don't know. So here's the first thing. Somebody comes to you and they say, look, I did it. I'm guilty. I still want an attorney. I want to hire you. Here's a bag of money. They hand you the cloth bag. It's got the big dollar sign in the front. You open it up, look in there. There's just wads of cash. Bundles of hundreds with those cool wrappers around them. Okay? It's just a big old pile of money. The guy goes, don't even count it. It's more than you could possibly want. It's more than you ever require. It's just a big old bag of cash. Now I need your help. He said, cool. Okay? So you're going to represent the person. Everyone deserves a good defense. And, I had people when I was going to law school from my previous life, especially the old radio stations, they'd say, Steve, I'm curious, how would you live with yourself if you were defending bad guys? Wouldn't you have a hard time sleeping at night if you knew there's a guy who's a criminal and you helped him get off or something like that? And I said, something, I don't know I'm going to do criminal work when I get out, but if I did, I would tell myself, well, everyone in America is entitled to good legal representation. My job as an attorney presumably will be to help these people make sure they get a fair shake from the court systems. Doesn't mean that everyone's going to get off for everything they're accused of doing, but we have also heard of the people who got railroaded because they didn't have good attorneys. So a good attorney is there to keep you from getting railroaded, if nothing else. And they'll help you, to help you get through the system fairly, okay? So if someone comes to you and says, look, I did it. I'm guilty. I did it. And you say, okay, I'm going to represent you. Now, there's nothing wrong with you representing them. You're allowed to represent them. No problem at all. But if they say, I want to go into court and I want to get on the stand and lie, okay? I want to testify in my own defense. I've got this great alibi. I'm convinced the jury's going to like me and they're going to love my alibi. And I want you to help me with that because, I'm going to get on the stand. So you, the attorney, have got to ask me the questions that I'm going to give the lies to, okay? Well, that's where you have a problem. Because attorneys are not allowed to help perpetrate a fraud upon the court. And so if the client told you, I am going to lie, they're saying, I'm going to commit perjury. I'm going to commit perjury. And you're going to help me commit perjury by asking me questions and letting me give lies as answers and then ask follow-up questions. And you're going to then present that to the jury and the court as being my truthful testimony, even though you're going to know it's lies. Well, it turns out there's a rule that says I can't do that. And it's in Michigan, it's MRPC Rule 1.16, declining or terminating representation. So they've already given you the bag of money. You may have already started working on the representation, and now you realize that they're going to commit perjury if you continue with them. So you can decline or terminate the representation. A lawyer shall not represent the client, or if representation is commenced, shall withdraw from the representation of a client if the representation will result in violation of the rules of professional conduct or other law. Okay? And then it talks about the different things that happen, including the attorney must inform the client about what's happening, and then the attorney must do what they can to notify the tribunal, the judge, court, and so on. And you don't go into court and say, my client's going to commit perjury. You just would go into court and explain to the judge as an emergency matter that's caused it to be where you can no longer represent this person. And so you need to withdraw, and someone else will have to step in and take over. And you'll do what you can to minimize that and help with the transition and so on. But the rules say specifically that you are to not represent that person, because continuing to do so would be perpetrating fraud upon the court. And so you are allowed to withdraw from that situation. And there are notes where they actually explain these rules. And it's kind of interesting about the rules of professional conduct. While they're kind of densely written and hard to understand, they actually have explanations below them, which most laws don't have, but these do. So a lawyer ordinarily must decline or withdraw from representation if the client demands that the lawyer engage in conduct that is illegal or violates the rules of professional conduct or other law. So that's that rule. So again, if the person is guilty, that's not the problem. The problem is if the person is guilty but says, I'm going to get on the stand and commit perjury. And likewise, if the person wasn't guilty and said, I'm going to get on the stand and commit perjury, you'd have the same problem. So it's not their guilt or lack of guilt that's the issue here. It's that they want to get on the stand and commit perjury. Okay, and there might be other problems you can imagine where a client could want to involve or do some kind of actions that are just repugnant to the law or the rules of the court. And in those situations, you may also find yourself in a situation where you need to withdraw. Now, here's the question that more people are concerned about, I think, than anything else, is someone comes into your office and they go, look, I need to hire you. Here's the bag of money. Okay, all my stories involve the bag of money because it's such a great visual. Big cloth, gunny sack type bag, tied at the top, dollar sign on the front, and you can heft it and feel the weight of those $100 bills in bundles, okay? There's only one back there. Imagine like 50 pounds of hundreds, you know? Put that on your desk. They go, here, there you go. There you go. That's yours. Just do a good job. It's yours. No matter what happens, it's yours. So you don't ask and they don't tell you whether or not they did it. And that's kind of a funny concept if you think about it. I had a professor at law school, a very, very good guy, and he did some court appointments over the summers once in a while just to kind of like keep his claws sharp. And he told our class one day, he said that he walked into a jail cell to meet with his client for the first time and on a really, really ugly set of facts. And before the guy opened his mouth, he said, shh, let me explain to you how it looks to me. And then I'm going to explain to you what I think the best defenses are here. And I'm going to want you to think about them for a little while and then tell me which one applies to you. And that's how he dealt with it. Now, here's the thing. We all know that somewhere down the road, you're going to sit down with the client, they're going to give you the bag of cash, and they're going to tell you a story. And you're going to find yourself in the back of your mind going, I think they did it. But you don't want to ask them that, right? And so you can ask the facts, what's the situation. But keep in mind that your client does not have to testify. And in fact, you don't want them to testify. You almost never want them to testify. So they're not going to testify. What they have to say about their own defense is limited in that sense. In other words, don't tell me what you would testify to because you aren't testifying. Now, you can tell me some of the facts and the things that might mitigate against you being guilty. But while you're talking to the person, you might come to the realization this person did it. They know too much. They've still got the bloody knife in their hands, that kind of thing. And so you're realizing this person sitting in my office is probably a murderer. They're probably a murderer with a lot of money, but a murderer nonetheless. And so I have people say, Steve, for you to defend that person, two things. Is it moral and is it ethical? Is it ethical? And see, that's the situation. Number one, let's address the ethical situation. I had a lot of people ask me when I was going to law school, and I said, I'm going to law school to become a lawyer. People didn't know I was going to go into lemon law, and I didn't even know that myself necessarily. And so they said, Steve, if you defend somebody who's guilty, how ethical? Like, how do you sleep at night knowing that? And I said, well, something, the reason I sleep at night doing that is because everyone deserves a good attorney. Even Charles Manson deserved a good attorney. O.J. Simpson deserved a good attorney. Everyone in America deserves to have fair legal representation who's going to help them through the process. Okay, so we've heard of people got railroaded for having bad attorneys. We don't want that to happen to people. Okay, this is America. So one of the things you get is legal representation, Gideon versus Wainwright, and that's something you're guaranteed by the Constitution. Okay, so the idea that I'm going to represent somebody and walk into the process, even if they're guilty, there's nothing unethical about that. And there's nothing immoral about that. I view that as something that is the job of an attorney. If you're accused of a crime, remember that until you are convicted, by definition, you are innocent until proven guilty. So that person you are representing is innocent. And as an innocent person, they have the right to an attorney. Okay? So morally, there's nothing wrong with it. But let's get to the legal aspects of it. So you become convinced that the person sitting before you is guilty as the day is long. They haven't admitted that to you, and they are not going to get in the stand and testify. They're going to sit next to you like a bump on a log and do nothing during the entire trial. Just sit there, okay? And people are going to testify. Both sides are going to call witnesses, experts, DNA, surprise witnesses, each more surprising than the last. Everything, okay? A full trial, but they're just going to sit there and do nothing. Okay, the rules of ethics specifically say that an attorney, even if they believe their client is totally guilty, has the right to make the prosecution jump through every single hoop to prove their case. And this comes from the rule 3.1 on meritorious claims and contentions. A lawyer shall not bring or defend a proceeding or assert or controvert an issue therein unless there is a basis for doing so that is not frivolous. Now, I could talk about that for weeks, and I might do another video on that, because I've encountered frivolous defenses all the time, and I've seen frivolous lawsuits get filed as well, and they shouldn't because it's unethical. That part of the rule is almost never enforced. But a lawyer may offer a good faith argument for an extension, modification, or reversal of existing law. That's how you can get somebody who files a lawsuit, and they lose, and they go, we understand we lost because the law is wrong. We're going to take it up on appeal and try to change the law. But a lawyer for a defendant in a criminal proceeding or the respondent in a proceeding that could result in incarceration may so defend the proceeding as to require that every element of the case be established. Okay? And there's a comment. Like I said, they have comments to these rules. The advocate has a duty to use legal procedure for the fullest benefit of the client's cause, so long as you're not abusing the legal procedure. So the point is that you might know your client's completely guilty. But as your client sits there, your client's innocent. Your client could be proven guilty, but the job of proving guilt is theirs. It's not your job to defend it in the sense of who's got the burden of proof. They have to prove it beyond a reasonable doubt. If they can't prove it beyond a reasonable doubt, your client's not guilty. So the onus is on them. They've got to prove him guilty, her guilty beyond a reasonable doubt. And so it's kind of like sit back and go, fine, you think you can prove my client guilty? Knock yourself out, but I'm going to make you jump through every single hoop, every single roadblock I can put in front of you. I'm going to pick your case apart completely to make you do your job. So the prosecutor's got to prove my guy guilty beyond a reasonable doubt, and I have the right to defend my client using everything that is ethically and legally allowable under the court rules and the law. So the guy comes in your office, says, I need you to defend me. Even if he's guilty or she's guilty, they still get the full boat as far as the defense goes. The only problem you really encounter is if the person were to tell you, yes, I'm guilty and I want to get on the stand and commit perjury. Want to help me? At that point, you say, I can't. And they say, what about if I give you another bag of money? You have to say, no, I'm sorry. It's not the bags of money at this point. It's unfortunately, the rules don't allow it. Now, the question that I think many people are thinking right now is they go, Steve, I got a question for you. We all know there have been situations before where somebody who is really, really guilty put on such a vigorous defense, or perhaps the person even got on the stand and testified. How is it possible that the attorney didn't know the client was lying? That's where you get in the gray area, because when I talk to my client, our conversations are privileged. You don't know what we talked about. So unless a client were to later come out and say, by the way, I committed perjury and he helped me, chances are the attorney can say with a straight face, I had no idea the guy's going to get up on the stand and lie. How do I know these are lies? That's his. I wasn't there. Unless that's your client's alibis, I didn't do it. My attorney did. Hey, I just thought of that one now. That's a good one. But the point is this: it would be a very, very hard thing to prove, and I've rarely seen it or heard of it. I'm sure it's happened before, but generally speaking, the idea that your guy's guilty and I'm going to help him get off, legally, somehow that imputing some guilt to me, it's almost never going to happen. So especially if my client never takes a stand, okay, then it's pretty much just I'm making the prosecution jump through all the hoops, cross all the T's and dot all the I's and cliche all the cliches. And once they get at that point, if a jury comes back and finds my guy guilty beyond a reasonable doubt, well, you know something? I did my job. They did their job. And now my guy goes to prison and I get to keep the bag of money. But I can keep the bag of money with a clear conscience because I did something that the rules of professional conduct allowed me to do. So Matthew, I hope that answers your questions. Otherwise, questions or comments, put them below. Talk to you later. Bye-bye.